Hello friends, this is Dr. Shashi Aggarwal. I welcome you all. Today our subject is business law and we are going to cover the essentials of a valid contract. Or we could say we are going to cover a very important question that every contract is an agreement, but every agreement is not a contract. If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Aggarwal. So this is my Edusum app which you could download from Google Play Store. It provides free study material to the students of commerce, economics and management. It also provides mock test to them for the preparation of competitive exam. It also offers structure courses. Business law is also available as a structure course. Now we will just revise, or we could say we will have a brief overview of the contract which we have covered in the previous video. So contract is an agreement to do or not to do anything. It is a legally binding agreement which is enforceable at law, which means legally enforceable means if the one party breach the terms and condition of the contract, the other party has a legal remedy that could go to the court for the enforcement of the contract. Section 2H of the Contract Act defines the contract as an agreement which is enforceable by law. According to Solomon, a contract is an agreement which create and define the obligation between parties. Frederick Pollock says every agreement and promise which is enforceable at law. So one thing is clear, contract is an agreement, and the second is if it is to be called contract, should be legally enforceable. So there are two essential elements of the contract: agreement and enforceability at law. So what is agreement? Agreement means when the one party makes an offer. So agreement means offer when one party makes an offer and the second party accept it. The offer is lawful, acceptance is lawful without any condition, then it becomes the agreement. And the second thing is it should be enforceable at law. If one party breaches the terms and condition, other party has the remedy to go to the legal remedy to go to the court. Enforceable at law means an agreement to become a contract must give rise to legal obligation. So contract is a accepted proposal and one party makes a offer and the second party accepts it. So it should be accepted proposal and the second condition it should be enforceable by law. The party should have the intention to create the legal relation. If somebody says, I will sell my bungalow to you for rupees 10, though it is not a contract. Here the intention is not to create any legal relationship. Only those agreements which are legally enforceable, they are called contract. All agreements, they are not contract, but all contract, they are agreements. Because agreement is a wider term, it covers the social and domestic agreement. But the contract means the agreement which are legally enforceable. An agreement to be enforceable by law must possess the essential elements which are contained in Section 10 of the Indian Contract. Section 10 of the Indian Contract Act 1872 enumerates 5 points that are very much needed for the valid contract. All agreements are contract if they are made by the free consent of the party. I will elaborate when we are going to cover the essentials of a valid contract. Competency, the party should be competent to enter into contract and the contract should be made for lawful consideration and lawful object and it should be not an agreement which is declared to be void. In terms of Section 10 of the Act, all agreements are contract. They are made by the free consent of the parties, competent to enter into contract for lawful consideration with a lawful object, and these are the agreements which are not essential declared to be void. Section 10 is not complete and exhaustive, so there are certain other sections which also contain the requirement. They should also be present. So these all are the essential elements which we are going to understand one by one. And there should be two parties. The contract involves two parties. One party makes the offer, the other party accepts it. Definitely, one party cannot make a offer to itself and the same party accept itself. So there should be minimum two parties. A contract could be made by a natural person, Ram, Cham, Gita, and the artificial person who are created by law, like ABC Limited, or we could say firm, they could also enter into a contract. A contract may be made by a natural person, the other person who are having the legal existence. In the case of state of Gujarat versus Ramlal and Company, there was a dissolution of the partnership. So they were distributing the asset among themselves. The sale tax officer wanted to tax that transaction, but the court said it is not a sale. Partners, they're joint owner, so they're not selling the things to each other. They're just distributing. So they cannot be both seller and buyer. Lawful offer and acceptance must be lawful offer by one party and the lawful acceptance of the same by the other party. If one like A is offering to B, I will pay you rupees 10,000. If you bid C, then it is not a, because here the purpose is not lawful. The offer is not lawful. A offer to B, I'm ready to sell I'm ready to sell my bike for rupees 50,000 to you. He said, it's okay, I'm ready to buy your bike for rupees 50,000. So A makes a lawful offer to B and B accept the sale. Then it becomes a agreement. And the party which should have the intention to create legal obligation. The intention to create legal relation. Social and domestic agreement, they are not recognized. Like in the case of Balofar versus Balofar, Mr. Balofar was employed in Salem. His wife, due to ill health, could not accompany him. She had to stay in England. Mr. Balofar promised to send her pound 30 pound per month while he was working in Ceylon. But Mr. Balofar failed to pay that amount. Mrs. Balofar went to the court and sued her husband. The court held the agreement among them was a husband wife. He was Balofar was a husband. It was a domestic agreement between the husband and wife, and there was no intention to create legal relationship. So Mrs. Balofar will not have any legal remedy. Lawful constitution. Constitution means when we are entering into agreement, what we are getting in return. Like A said, I will paint your picture for rupees 200. So B said, okay, you paint my picture, I will give you 200. So A, in return of painting the picture of B, will get 200 in return. And B, by paying rupees 200, he will get his picture painted. So what we are getting in return? The constitution should be lawful. It is an essential element in a contract. Gracious promises which are without consideration, they are not enforceable at law. Consideration must be lawful. It should not be prohibited by law. Section 23 states that the consideration and object should not be unlawful. An agreement made without consideration is a void under Section 25, but there are certain exceptions. A promise to obtain for B employment in the public service. He promised to pay 10,000 rupees to A. So this agreement is void as the consideration is unlawful. Capacity of the contract, capacity of the parties. So the party who are entering into contract, they should be competent to enter into contract. Party must be competent to enter into contract. Section 11 of the Contract Act says the following person, they are competent to enter into contract, who's the age of the majority according to the law to which is subject. Like in India, it is the age of 18 years old. The person should be of sound mind. The person is of unsound mind, then he is not competent. And the person who is not disqualified by the law. A minor, lunatic, idiot, and a drunkard person cannot enter into contract. And the person who is of unsound mind, the person who is a minor, we cannot enter into contract with him because the agreement which we made the minor or unsound mind, they are void from the very beginning. Pre-consent. Consent means The party must have agreed upon the same thing in the same sense. It means consensus ad item. The mind of both the party must be ad item. Two party must have agreed about the subject matter on the which the contract is based. They should understand and interpret the subject matter the same way, the same time, and the same sense. Like A wanted to sell his red Maruti car, but we thought A wanted to sell his red steam. So there is no meeting of mind, there is no consensus at all. So it is not a contract. Section 14 of the Contract Act states that the contract is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. And the object and the purpose for which the contract is made should be lawful. Section 23 of the Contract Act states the object of the contract should not be prohibited by law. It should not be creating fraud with each other, involving injury to the person or property to the person. The court regard it immoral or opposed to public policy. Like four person, they make a agreement. Okay, we are going to rob the bank. So here the object is unlawful. If there is a dispute about the looted amount, then they can go to the court because it is the object is not lawful. And the agreement not declared to be void. Agreement must not be one of those which have been expressly declared to be void by the Act. Section 23 to 30 explain there are certain type of agreement which are expressly declared to be void. So these are void agreement. Like unlawful agreement, section 23 and section 24, agreement without consideration, section 25, agreement in restraint to marriage, section 26, agreement in restraint of trade, section 27, agreement in restraint of proceedings, section 28, uncertain agreement, wagering agreement, agreement to do impossible act, section 56. Certainty of meaning. According to Section 29 of the Contract Act, the terms of the agreement must be precise and certain. It should not be vague. Vagueness means we could not understand. It should not be vague. He agreed to sell to B 100 tons of oil. So here we are not going to understand which type of oil, which quality of oil is going to supply to B. So here the terms and condition of this agreement they are vague. So it cannot be called a contract. Possibility of performance. If the act is impossible in itself, physically or illegally, like a singer who has lost his voice, definitely he will not be able to sing. It cannot be enforced at law. Section 56 of the Contract Act states that an agreement to do an act, if it becomes impossible, then it is a void. Like A agree with B to put life into B's dead brother. So this agreement is totally void. Void means it will not have any effect. We will not have any legal remedy. Formalities. If the required legal formalities they are not carried out, the agreement will not make a valid one. All the above elements they should be present in it. If one of them is missing, the contract is either voidable, void, illegal, unenforceable in the eyes of law. To be contract, the agreement may be oral or in writing. If any legal formality is required by the law, then it should be fulfilled. Like if the law requires the agreement has to be in written form, it should be properly registered and it should be properly stamped, then it will become valid if it is written, registered, and properly stamped according to the law. When a particular type of a contract required by law is to be in writing and registered, it must comply with the necessary formality as a writing, registration, and attestation. It is essential for the validity of the contract. It should be in writing, signed, attested by the witness, and registered if so required by the law.